Okay.
Good evening, everyone. I see Ajinkar Randive, Managing Committee Member on behalf of Pune branch. Welcome our today's speaker, CA Darshan Balai, and all the participants for today's virtual CP meeting on labor laws and labor codes, overview and must-know facts for professionals. As we know that the labor law, being a practicing CA, we are more into the auditing this thing, and the labor law is one of the most important aspects that one should know while auditing any entity or preparing financials from compliance point of view and everything. But somewhere we lack the exact knowledge. What I feel is that we lack the exact knowledge that practicing professional should have, at least from the auditing point of angle. So I welcome CA Darshan Balai once again, and we will start with today's seminar. Thank you, Darshan, and over to you.
Yeah. Thank you, Ajinkya. I welcome you all for the labor law and labor codes presentation. So I'll start with sharing the screen. Yeah. I'm going to focus on the practical aspects of labor law compliances. So the effort is to consolidate whatever knowledge I have over the last 10 years of practice into labor laws. I've tried to consolidate into 2 hours of, if I may say, insightful session. And the focus area is very much professionals. So as professionals and as auditors, how, in spite of not being subject matter experts, we can contribute to clients' compliances, and at the same time, we can also ensure that they do not face any pitfalls, which typically I come across many cases where there are a lot of, some non-compliances due to lack of knowledge.
Darshan?
Yes. Yes,
so,
Ajinkya.
Yeah, sorry to interrupt. Just moving ahead, I would like to introduce to all the today's attendees. I'd just like to give a brief about you. So Darshan Balai, who is a past CA in first attempt in the all his exams. In all India, he's ranked 14th rank in CA CPT in November 2017. His 7th rank in CS intermediate exam. Worked in Suzlon as assistant manager for 1 year in 2012-13. MBA from Coventry University London campus. Director of Payroll Services Private Limited since 13-14. Speaker on various forums, specifically delivered lectures at CREDAI National Level, Grethor Webinar Series, ESI Pune Office, induction of SSO ESI inspectors on how to study financials. Being a director of the payroll, his payroll company. His company is all about payroll and compliance. And so Darshan is the perfect speaker for today's session. So Darshan, I can thank you, and we can continue with that. Sorry to interrupt.
Yeah, no problem, Ajinkya. I think that was a sweet interruption. So I'll move. I will just break the session into various different components. Like I already mentioned, the objective or the focus point is how, as professionals, we can make a tangible contribution to clients' compliances and also help him avoid pitfalls in the compliances. Unfortunately, the labor law compliance area is very much unstructured, meaning unfortunately, there are various professional and non-professional elements who are guiding the compliances of clients, and most of the times we observe that the rules or the exact provisions are on the back burner and compliances happen in a very, if I may say, unprofessional manner. So my effort during the course of the session will be to first, there will be three to four different parts. First will be to typically burst the myths. So when I say myths, what I mean is there are lots of misconceptions about labor laws floating in the market, and specifically amongst the professionals. So I come across many such queries from my professional friends, for which I think this will be a very good platform to bust those myths and have a reality check. Secondly, I am also going to explain you some very insightful points which can certainly contribute to your clients' compliances and probably optimize the labor law compliance cost also without by fitting within the legal framework. Of course, I'm going to touch upon labor codes. When I say labor codes, frankly, at this point of time, I'm not very optimistic about labor codes for various reasons. But because it is one of the burning issues, we need to understand what it comes with and what it has for all of us. And probably I am also going to talk on how what areas as an auditor you need to look into from labor law point of view. And of course, salary structure, a basic salary structure with maximum tax benefit with whatever limited avenues we have. Okay, so these are going to be the different parts of the session. At the outset, friends, I'll be very clear that I need to create a distinction between a typical tax law and labor law. So for a tax law, the beneficiary of the tax laws is direct, more or less the government. When I say beneficiary, what I mean is when you pay the GST, it does not go to any individual or any SSC, it goes to the government. Whereas for labor laws, government plays the role of a regulator and the direct beneficiary is the public at large, or if I may say the organized workforce. So because of this distinction, the penal provisions under labor laws are much more strict to the extent that almost in all the laws, imprisonment of the principal employer. When I say principal employer, I mean the person in charge of day-to-day affairs of the company or the business, typically the director or the partner. They are susceptible to imprisonment provisions. Of course, it's a last resort from the department point of view, but it is an essential fact to know so far as labor laws is concerned, because that will set the tone for how serious these labor laws are and how sincerely the SSCs or the establishments should consider these laws. One more point is, friends, most of the departments, typically I'm going to focus on Provident Fund and ESIC, they have quasi-judicial powers, and all the assessments happen in that manner as if they have all the powers of a judge, right from summoning any individual or summoning record to enforcement of attendance of a particular individual. I'll move to the first slide of the presentation, friends. So this is a concise list of typical myths which I come across as a practitioner in the labor law area. So in fact, I'm sorry to say, but many professionals are also not very clear about these aspects, and I think it should get addressed in this session. So the most common myth or misconception is PF is not applicable above 15,000. I'm going to burst it during the course of the session. Then if I divide employees into different firms, typically a domestic business or a local business or a family-owned business, there are multiple firms in which employees are divided purely to save PF compliance cost or PF applicability, because PF is applicable on 20 or more employees. But I would like to put it on record that PF and ESI, these two major compliance laws, if I may say, there are clubbing provisions. Similarly, if I may draw similarity to Income Tax Act, similarly in PF, if the employees are divided into two different firms, but the two firms are functionally integral, then the department authorities can club those establishments and make PF applicable. So this is section 2A of the PF Act. Similar laws clauses are there under ESI. One more very typical myth is, if I add the typical why we hesitate to add in PF is he will become permanent. That is not the case, friends. PF operates in a very, if I may say, streamlined way, very online workflow. There is a very defined workflow for employee addition and exit. And addition of employee on PF does not in any way make him permanent with my establishment. Of course, it creates his employment record, due to which other labor laws will become applicable. To be more precise, say gratuity, for example. So that is one of the myths that we need to address. Again, point number 4, 5, 6 during the course of the session I'll address. 7 also. One more important point is labor license. So many inquiries I get where a contractor comes and tells me, Darshan, I want a labor license because I need to get a contract. It does not work in that fashion, friends. The chronology is you need to take the contract and after that you can apply for labor license. So one of the required document for labor application is a work order copy of, or if I may be more particular, it's called Form 5, which is a certificate by the principal employer. So it does not operate in that way that you take labor license and then apply to various companies for manpower supply contract. It's other way around. Once you get a contract, you can make an application for labor license. Labor license is per site. So I may have multiple sites. For each site, I need to take one labor license. It is not like one license for the entire organization. One more important query I come across is, Darshan, I have my employee count is much below 20 now, and I want to discontinue or withdraw my PF registration. Friends, section 1.5 of PF and similar section of ESI Act very categorically states once the company is registered, the registration cannot be withdrawn irrespective of the employee count. So it's a one-way street, friends. Once you register with PF ESI, it cannot be withdrawn or closed until the company is completely shut down. When I say shut down, I mean liquidated or the partnership form is dissolved. One more important misconception is gratuity can be part of CTC. So that is not the case. Gratuity should be independently paid by the company out of its pockets, because you cannot recover gratuity from employee in the form of monthly contribution. Now I'll focus on the first point. PF is not compulsory. That is not the case. I'll jump to a particular slide. So if you can see the extreme right column here, friends, extreme right box. In this, what are the preconditions? So as a consultant, as an advisor, I generally advise my clients not to park any employee as excluded or keep him out of PF coverage. Reason being, one, there is not just one, multiple conditions to be fulfilled. Number one is that basic salary. So when you say salary, it consists of various different components like basic, HRA, and various different allowances. So the basic salary at the time of joining should be above a threshold limit of 15,000. That is condition number one. Condition number two is before joining your organization, he should never have been PF member ever in his life. So even if he has contributed for one day in his previous employments, then that individual, that employee is not allowed to keep himself out of PF. And of course, the documentary evidence is you need to have Form 11 in place. So Form 11 is a exclusion form wherein an employee gives a declaration that I do not want to be part of PF and I was never a PF member earlier. So this document is very critical, friends. And I have seen cases where lakhs and lakhs of dues have been assessed just because in Form 11 employer signature was missing, or one of the document, or the document did not look authentic, or the originals were not submitted. So Form 11 is one of the very important documents which I'm going to display during the course of the session, which from every employee as a part of joining document, it should be availed from the employee and it should be kept on record. It need not be submitted. It is only in the case of inquiry. One important point, friends, department has ways to find out if he was a PF member. Everything so far as Provident Fund is concerned is Aadhaar linked. So the moment you say a particular employee was not a PF member earlier, the authorities can just feed in the Aadhaar number and can find out if UN is there. UN meaning universal account number, which is unique to an individual for the PF account number to an individual for his lifetime. Okay, so so these are some of the myths which I believe that we need to address. Now I am going to come to a very common law, very fundamental law. This is, if I may say, one of the foundation document for a particular any commercial establishment. And I'd like to touch upon some of the important aspects of provisions mentioned in the Shops and Establishments Act. First and foremost, leave encashment. I am mentioning this because when you do audit, or if payroll statements are verified, or you're doing the payroll for any of your client, you may have come across leave encashment being paid probably on a monthly basis or in the month of December. Now, Shop and Establishment Act clearly states that leave encashment needs to be done only at the time of FNF. So during the course of employment, leave encashment is not compulsory. It is optional. If employer is giving the leave encashment, of course, the government is not going to object to that. But if it is not given and only leave balance is allowed to be carried forward from one calendar year to another, it is absolutely fine. Okay, so only at the time of FNF, and that too for rejected leaves. So so basically the guiding principle is leaves are meant to be availed. They are not meant for encashment. So if the employee has never ever made an application for availing the leaves and he leaves the organization and there's a leave balance, as an employer, you can take a stand that I am not liable to encash your leaves because you have never applied. In case he has applied and the employer has rejected the leaves, then of course, at the time of FNF, leave encashment is mandatory. And according to me, it has to be paid on gross salary. Corresponding income tax provision, friends, that leave encashment only at the time of FNF is exempt. So if you can see the parity between the two laws, how they are working in tandem, leave encashment during the course of employment is taxable. So these two go hand in hand. Leave provisions, Shops and Establishments Act. Okay, I'll come to that later on. I was also talking about women employees. So for women employee, typically in the BPO sector, if women employees are working in the night shift, it is mandatory to have Form 11, which is a consent form from the women employees that they and certain conditions have been imposed on the employer that he needs to fulfill in order to engage women workers in the night shift. Okay. Some more important provisions, friends. If the employee count is below 9, Shop Act intimation is required. Since last 2 to 3 years, probably around 2017, when new Shops and Establishment Act has been gazetted by Maharashtra government, they have categorically made some changes. Change number 1 is Shop Act registration fees is not required. Change number 2 is if your count is below 10, you need not take license. So it's basically to avoid red tape. So you need to just fill in the form and take a printout of that slip, which is called intimation. So no approval by the authorities if employee count is below 9. So this is a major relief for small business owners. And frankly, it's a very less time consuming process. Shop Act license is required if you have 10 or more employees as per the latest laws. And one more important point corresponding to this is government has waived off Shop Act registration fees. So only online 23 rupees is what you have to pay. Corresponding notification is that if you want to renew the license, once you take a license over the last 1.5 years now, it is not required to be renewed. It is a permanent license. So typically the whole objective is to avoid discontinue red tape in this, which was a major hassle against ease of doing business. So these are some of the important provisions of Shops and Establishments Act. One more important point, friends, for leave balance working, calendar year has to be followed. Why I've mentioned this point is because I come across various such cases where every financial year wise leave balances are either encashed or carried forward. It should be happening in the month of December and not in the month of March. So I was talking about leave provisions. This is a very short summary of what kind of leaves an employee is eligible to avail. I'm not going to get into the technicalities for in the interest of time, but what I want to focus on is that only maximum of 45 days can be carried forward, and casual leaves cannot be carried forward. Only earned leaves can be carried forward. Secondly, holidays. Okay, so there are 4 national holidays, if I may name: 15th of August, 26th of Jan, 2nd of October, and 1st of May. These are mandatory national holidays. And apart from this, you need to have 4 festive holidays, which are optional depending on the employee's choice. So these are some of the provisions with regards to Shops and Establishments Act leave entitlements. I would like to also show you the form L, which is a consent. So you need to address this and ask if you have any clients who are typically BPOs where women workers, or any KPO where women workers are working night shift. This is a mandatory consent form which your client should avail from every woman employee, amongst other conditions. There are various other conditions which I'll not get into. So yeah, so this is a Shop Act license which we have recently availed for one of our client. And if you can see this particular point, I have just highlighted the validity of this license is lifetime. It is permanent. So this is a very important amendment from the Shop Act provision perspective, and I believe that your clients should know that such provisions or such amendments have happened over the last 2 to 3 years. And over to Factories Act, I have included this in the presentation because of ignorance about this concept. I'm just going to focus on applicability. Like I mentioned at the start, the focus is only to find out what are the pitfalls, what are the areas where you need to ask questions. I'm not going to get into the technicalities. Factories Act, I would first like to mention that manufacturing process as defined in the Factories Act is very wide. When I say so, any activity which involves repairing, altering, finishing, packing, oiling, washing any article or of substance with a view to change its substance or with a view to change its form is called a manufacturing process. Even pumping of oil, water, is also manufacturing process. Even generation of power is a manufacturing process. So this is a very wide definition, but of course the applicability is not restricted to manufacturing process. You need to have 20 or more, I suppose worker is a misguiding word, employees or workforce in the manufacturing unit. So factory license, like Shop Act license, is unit specific. What I mean unit specific is if my client has 3 different factory units at different locations, it could be say at a very close vicinity. In spite of that, for each location you need to first assess the applicability, and then you need to take license. So second condition, like I mentioned, is you need to have 20 employees. So when I say 20 employees, I mean even staff members of the office associated with the factory unit. So typical factory unit layout is there's a factory unit and there's an adjacent office building. So even those employees are counted. Needless to say, friends, that contractual workforce is also counted. So in fact, for all the labor laws, as I'm going to proceed during the course of the presentation, contractual workforce is also considered for factory license applicability and almost all other labor laws. So one more important amendment or a takeaway, again from ease of doing business, is if you have a non-hazardous factory, there is a scope for taking a conditional license. According to Right to Services Act, the authorities are bound to revert or process a conditional license application within 7 days. Practicalities are different. I'm not going to get into that, but you can avail a conditional license for 1 year. So with the help of this conditional license, which typically authorities should grant within 7 days, you can start manufacturing process. Conditional license comes with certain conditions which can be fulfilled over a course of 12 months. But important point is it is only for non-hazardous unit. So I have also given you some examples, friends. You can see I was talking about it definition being very wide. So even a fuel pump station is a factory according to Factories Act. And I have come across many units where they have availed factory license and renewing from time to time. So in fuel pump station, being a hazardous unit, you need to take license even if your head count is below 20. Second, typical example is a service station. So 2-wheeler or a 4-wheeler service station is also liable to take factory license because of repairing work which happens at these service stations. So this is about Shops and Establishments Act and Factories Act, which typically operate more in the license form, and some compliances are there. I'm going to talk about PF ESI applicability. This is according to me, a very important topic of the session. And as professionals, we need to brief our clientele about these applicability provisions. I'm going to draw some points from the first slide where I was talking about an excluded employee. Typically, I'm going to set an example. If my organization has 20 employees, out of which 15 employees are excluded employees, as I explained during the initial part of the presentation. When I said excluded employees, I meant that their basic is above 15,000 amongst other conditions. Then even those excluded employees are counted for applicability. For applicability, all employees are considered. For that matter, even contractual workforce. When I say contractual, what I mean is any employees who are operating within the premises of my factory, shop, or office, but through a third party, even that workforce is considered as employees for ascertaining the applicability of PF. So if my client has 16 employees on roll and 10 employees are working in my client's godown as say storekeepers, then legally my client has 26 direct and indirect workforce, and hence PF is applicable. So second important point is I come across various queries wherein someone says, say, Darshan, my client is an NGO, it's a charitable institution, or for that matter, it's a proprietorship. So are the applicability provisions, or for that matter, labor law provisions, the same? Friends, like I mentioned in the first slide, it is a beneficial legislation. The beneficiaries are your employees and not the government. So government has not created any disparity depending on the constitution of business, be it proprietorship, even for that matter, charitable institutions. All the applicability laws are more or less the same. There is a particular exception to this, typically a cooperative society, for which there is the provisions are little different. I already spoke about clubbing provisions. One more important point, friends, ESI is applicable even for non-manufacturing units. And for ESI applicability, same logic applies, like I mentioned for PF. Typically, ESI has to be paid only for employees whose gross salary is below 21,000. Having said that, even if I have one such employee and there are 10 employees who are drawing about 21,000, law is applicable. I need to take registration and do the compliance for that one employee. So similar to how I explained in PF, I also explained to you that closure of availed registration is not possible. Even for a voluntary registration under PF, there is a scope for voluntary registration, section 1(4). But even a voluntarily registered establishment cannot discontinue its applicability or discontinue its compliances if the employee count continues to be below 20. Labor codes which are going to get implemented one day in the one fine day, there is a scope for withdrawal of such voluntarily availed registration, but at this moment it cannot be withdrawn. One more important point, friends, whenever you have a voluntary registration under PF, once the registration is done, the law remains the same. So there is no scope for choice on the part of employee to really go in or out of PF merely on the grounds that it is a voluntarily covered establishment. So I'm using the word establishment because this is if I may say, legal terminology used in almost all the laws, like we used SSC in various tax laws. All these laws talk about establishment as as the SSC. So again, this is one of the very burning issues. Friends, I would like to invite your attention to this particular official gadget. So this will be very handy for you. Typically from 15th of Feb 2020, if you have taken a if you incorporated a private limited company as a you get PF and ESI registration along with the incorporation. So these are provisional registrations. So over the last 2-3 years, I have come across various notices and inquiries from departments, mails stating that you have taken a registration but not filing the returns, against which I have been using this gadget. So this is a very handy gadget in which very particularly the government labor ministry has categorically stated that the above companies will have to comply with the provisions only once they cross threshold limit of employment. Corresponding to this, the applicability provisions of PF and ESI continue to be the same, wherein you need to have 20 or 10 employees as mentioned in ESI. So with those supporting documents, we are able to keep applicability at arm's length, at bay, because of this gadget, and we are able to respond to departmental inquiry and tell them that once we have the threshold limit, we will do the registration. So one more important point, friends. One fine day, if your client is going to cross threshold, PF and ESI login details are must. So please advise your clients to keep them handy with them. And generally, it is issued by MCA on the primary email ID and the mobile number. So it has to be kept on record. Under ESI, there is a particular provision which states that you need to keep updating every 6 months. Unfortunately, it's a very futile exercise, but it has been issued under notification, but not many companies are doing this auto update every 6 months. I also want to talk about ESI applicability. One point I missed is that, like I mentioned, even for service sector, non-manufacturing employee applicability continues to be 10 employees, not 20 for non-manufacturing as well in the state of Maharashtra. The only exemption is educational institutions. When I say institutions, I mean only schools or registered educational bodies like schools, colleges, universities, and hospitals. But if you're running a private coaching class, or so for that matter, diagnostic center, or any pharma related say marketing firm, ESI is very much applicable to such establishments. For that matter, even these schools, colleges, if there is a contractual workforce. So when I say contractual workforce, I mean say housekeeping or security guard. ESI is applicable for those contractors, even if they are operating for an exempt unit like a school and a college. Corresponding, if I may say, professional advice on this, I as a consultant generally advise my clients to go for contractual workforce for various compliance costs. Typically, they will levy GST, they will also levy service charge, and unfortunately, by having a contractor, so this is the first point on the left-hand side of your slide, that this is again one of the, if I may say, misconceptions which needs to be addressed, is that if I engage any contractual workforce, if I divide my workforce into myself and I outsourced my manpower to a contractor, I, as an establishment, as an employer, do not escape any labor laws. When I say that, what I mean is that in almost all these labor laws, they have established a principal employer and a contractor relationship, wherein any contractual worker, for him, even if the contractor is an immediate employer, the contract giving agency or that main company is the principal employer. So if the contractor defaults on any of the compliances, principal employer can be held liable, to the extent that any bi-party agreement. So typically, I also see many cases where the client says that, Darshan, I'm going to write it on the contract with the contractor that, all labor laws is his responsibility and we are not liable for any compliances. If any dues are assessed, we are not liable. Unfortunately, it is legally speaking, any law supersedes bi-party agreement. So typically, law has already put the onus on the principal employer. So any bi-party agreement will not stand any departmental inquiry for that matter. Also, typically, I would advise many times, typically in IT setup, I see that many employees or workforce is engaged as consultants. So when I say consultants, it, like we all talk in accounting language, there's substance over form. So more than what it appears on the paper, even if you have had a consultancy agreement, but if there is employer-employee relationship which is established, typically he's availing all the benefits and responsibilities of an employee. Mere nomenclature and even treatment in books as consultant may not suffice. So kindly use this consultancy route only for genuine arrangements. For example, in a hospital, there are RMDs, resident medical doctors. They are full-time employees from labor law point of view. So mere treatment of them as consultants, they will not escape labor law provisions. But if you have a visiting doctor who comes for particular hours in a week or for only for the case of surgery, those are surely your professionals or consultants and not liable to be treated as employees. Similar example is typically we as CEAs, we also give various retainer client services. Say particularly one day in a week, I visit to my client's place and do some kind of internal audit or some CFO services. So this is also not an employer-employee relationship. So I have given these examples to clearly establish what accounts for an exempt consultancy agreement. Otherwise, more or less, labor laws are applicable. Of course, unless you go through the inquiry process, it may not get detected. So, but as a preventive measure, you can always advise clients to be very particular, careful about consultancy agreement. I'm going to come to ESI and workman compensation. Again, one of the myths which or misconceptions is, Darshan, we have taken a WC policy, that is worker insurance, so I'm not going to pay ESI. Unfortunately, it is not a complementary applicability. When I may say complementary, what I mean is that if ESI is applicable, you need to do ESI compliances. Workman compensation does not suffice in replacement of ESI. In case ESI is not applicable, WC is compulsory. So very important point, specifically for construction contractors, friends, construction contractors, when I say contractors, I mean wherever a contractor is engaging a construction labor at a particular building or in say road construction or say dam construction, any infrastructure project, construction worker is exempt. Wide Supreme Court judgment, and there's a corresponding ESI circular also. So those workers are not liable for ESI payment. I have come across so many cases where contractor has been paying ESI, and it is if I may say, wastage of finances by making these payments. I have already covered the excluded employee provisions under Provident Fund. Just for the sake of information, under ESIC, if gross salary is about 21,000, employee is legally out of ESI coverage. Okay. I already mentioned this, so I would like to show you a corresponding notification. So I think this is the notification where law was made applicable, but after Supreme Court intervened, this was stayed. So this is the notification which I was talking about, wherein extension dated September 2018. Very clearly, they have stated that during the stay period, ESI may be or not. So it is clarified that no ESI contribution may be collected from the construction site workers. So I'd like to also brief you that office staff, say site engineers, project in charge, architects who are working on a construction site, drawing salary below 21,000 are liable for ESI coverage. Only workers at a site are exempted as a result of this stay order. So I will also move to the very interesting part. So we are moving to a part where I'm also going to brief you about what are the benefits which you can avail as a contributor to these laws. Particularly, I'm very very distinct about this benefit, wherein if a women employee, you might be aware that for a women employee, maternity benefit is payable by the employer, wherein the employer has to pay 26 weeks, equivalent to almost 6 months of paid leave to a woman employee who goes on a pregnancy leave. Now, if that employee is covered under ESIC, as an employer, you need not pay 1 rupee to an employee. Entire benefit is disbursed through the ESI department. So this is a very fruitful benefit to ESI contributing women employees, and your clients need to know that such contributing ESI members, employer is not liable to pay maternity benefit. So whenever someone comes and asks me, Darshan, she's going on maternity leave, how much I need to pay? The first question I ask is, whether she's covered in ESIC. If covered in ESIC, please ask her to apply to ESI and take the benefit. Similarly, I'm also going to talk about Provident Fund. What are the benefits? These benefits are in the interest of public at large. They need to know. Provident Fund pension contribution is typically for retirement superannuation. And if you contribute for 10 years, or if I may say 120 months cumulative during the course of your employment, wherein say you work up to the age of 58 years, then you generally contribute 8.33% of basic, subject to a maximum of 1250 a month. And once you become eligible for pension, central government contributes 1.17%. So it's 9.5%, and corresponding benefit is available to you. One more important benefit under Provident Fund, which is death benefit under PF. So what I mean by death benefit is that if a member expires while in employment, so he should be an active PF contributing member. He may expire for whatever reason. It could be through heart attack or through employment injury. If he has contributed for 12 months, his nominee is eligible for a minimum insurance of 2.5 lakhs to a maximum of 7 lakh rupees. And over the last, I'm proud to say that over the last 3-4 years, we have processed almost 8 to 9 death cases, and the benefits range from almost 2.8 crores, 2.8 lakhs to 4.84 to 5 lakh rupees. So many of our, if I may say, acquaintances or clients' employees have got this benefit. Of course, little bit of paperwork is involved and some kind of licensing, some kind of follow-up is needed, but this is a major benefit which is available to a subscribing member. In fact, the EPFO has clearly guided or instructed its offices to process death cases within 7 days. Practically, of course, we face some challenges, but the intention is very clearly set by the EPFO. Additional benefits under PF is that the nominee, typically the wife or children, they get pension for rest of their lives. Children till the age of 25 years, and nominee, say spouse or parents, get their pension for rest of their lives, 50% of the pension which an employee would have been eligible for. So this is a important, if I may say, takeaway, which I suppose needs to be known. Now I am going to focus on penal provisions or inquiries. I am going to take the analogy of, typically the guiding principle is you need to avoid any inquiry. So for what are the triggers for the inquiry? One of them is if you do not pay within 15th of the following month. So it's very important that you ensure that you do not miss the deadlines. If you miss the deadlines, amongst other consequences, one of the consequences is if they have categorized as category A, B, C as defaulters. So if you delay for say 6 months or more, it's category A. So they have given such default categorization, and you need to ensure that you do not default on PF payments, PF and ESI payments for that matter. In fact, I would go to the extent, if I may candidly put, that even if you pay PF for one employee, but the return has to be filed. So we ensure that return goes and gets filed, even if that saves you from any inquiry. So the approach should be to avoid any inquiry. So typically, if I am going by road, we generally come across, or traffic police typically catches person if there's an eye contact. That is how I operate, and wherein I have been caught many times because I have failed to miss the eye contact. So if you can bypass that, you will be able to save yourself from PF ESI inquiries. Of course, under ESI there is also provision for filing of nil returns. I would also generally advise, specifically decline of country challan amount should not majorly fluctuate. Increment is fine, but decline of more than 10% is susceptible to inquiry. Just for your information, all these inquiries are initiated by the Central Intelligence Wing which analyzes this data, and then inquiries are initiated through randomly or through this intelligence input which they get. One more trigger for inquiries, of course, employees go and file the complaints. So if any such complaint reaches the department, that is a very clear case for inquiry. So avoid doing that. And of course, if there is a closure of an establishment non-functional, I have come up, it's unfortunate, but if I make an application for closure of PF code, typically they do something called as pre-closure inspection. So this kind of pitfalls, if I may say, we should avoid, and I'm sure we will be saved from a very tedious and a very, if I may say, harassing exercise of these inquiries, because it is not a straightforward route, even if the compliance is more or less done. This is a very important slide of the presentation, wherein I'm also going to demonstrate how you can save the client's penalty and interest merely by a small trick. Okay. But first, let me focus on what are the consequences for delay. Believe me, friends, amongst other tax laws, these consequences are much more draconian and much more severe. Specifically, you need to pay interest at the rate of 12% per annum. Apart from this, you're liable to pay penalty to the extent of 25% per annum if the delay is more than 6 months, and subject to a maximum of 100% of the challan amount or the dues. So 25% per annum subject to 100% of dues is liable as penalty. So a client who has defaulted on, say, 100 rupees of PF might end up paying 100 rupees as penalty and 12% interest on that. Amongst other things, of course, disallowance is there under section 3615A, income tax section 43B, employee share and employer share. There are certain benefit schemes also, which have been there specifically from Provident Fund. There have been fantastic schemes, and we have been able to take over 5 crores of benefits through 2-3 different schemes for our clientele. And of course, they come with certain terms and conditions, and one of the condition is payment of this PF within the timelines. I was explaining to you how I'm going to demonstrate. Before that, I would like to invite your attention to various various circulars. Specifically this one, PF is penalty never ever is waived off. This is, if I may, to best of my knowledge, first and the only instance where the EPFO has completely waived off penalty for the lockdown period, typically April 20 and May 20. So if any of your client has delayed or defaulted on PF payments, they can save on the penalty. So the word used is damages. All right. So typically, I was talking about how you can save the damages merely by doing a small trick. So this is what I have tried to demonstrate on this Excel. If you can see very clearly, the client wants to pay 48 lakh rupees of PF dues for 22-23, for which the funds available are in this form, wherein on 15th of April, the client is willing to pay 6 lakh, and 15th of October is 24 lakhs and 24 lakhs on 15th of October. Like I mentioned in the slide, friends, the penalty is incremental, rate is incremental. So 5% up to 2 months, 10% up to 2 to 4 months. So if the delay is in the bracket of 2 to 4 months, it will be 10%. But if it crosses 6 months, it will be 25% from day one, right? So what I have done is, if typically this is a straightforward way wherein client, as the funds become available, first he pays off the first 6 months in the chronology, and next 6 months in the next installment. The client is ending up paying 25% penalty. Now I have reversed this payment cycle, wherein what I have advised my client is, if you have 24 lakh, you don't have entire fund, first pay the latest month. So by doing this, he had saved almost 61,000. This is a very hypothetical example, but I've just explained to you how merely by arranging the payments chronology, they have saved the penalty. Apart from this, of course, in the last month, because he's paid on 15th of April, he has also saved on 3615A disallowance, right? Which is very strict. I mean, very clearly, even if there's 1 day of default, the employee share is disallowed. So in this case, if it's in the 30% tax slab and 2 lakh is the employee share, then 30% of this, if I may say, almost 60,000 he has saved towards disallowance merely by paying this within the due date. So I hope the message is very clear in terms of how you can arrange clients' delay payments. Same applies to ESIC, friends. More or less the default provisions are same. Yeah, so I'm going to talk about some important aspects of PF. I have already mentioned. Again, if there is a shortage of funds and client has been defaulting, it is advised there is also an option to pay only employee share of PF. So if client has is short on funds, if he continues paying employee share, he achieves two benefits. One is 3615A is not violated, and secondly, the default is not liable for criminal action, because employee share once deducted has to be paid. So he will be saved from imprisonment provisions if he continues to pay the employee contribution of PF. I already mentioned point number 2. Point number 3 also has been mentioned. I would also like to invite your attention to some of the important PF notifications, which could be very handy for your client. Typically in IT setup, there's a CTC concept. So the authorities during inspection might take a stand that employer share cannot be recovered, to which the answer lies in this notification, wherein the department has taken cognizance of CTC concept and it is allowed as as long as it is documented in the appointment letter and clearly explained to the employer. Similarly, I would also these are some important guidelines. I'll just rush through them. Specifically dated 14th of Feb, wherein this is specifically to counter the high-handedness of the authorities, wherein authorities rampantly initiate inquiries, to which the answer lies in this notification, wherein it is clearly stated that unless there is a prima facie case of default, and it has to be put on record by the authorities, that is the PF inspector, more specifically called as enforcement officer, and it should be on record. A show cause notice has to be issued to the establishment, in response to which, if establishment fails to respond to that appropriately, only then a 7A inquiry. So 7A is, if I may create a parity, it's more like income tax scrutiny, where a detailed inquiry happens in a quasi-judicial manner, wherein APFC or RPFC finally issues a speaking order. So 7A inquiry is used as by many, unfortunately, authorities and, if I may say, unlawful elements to scare the employers, but there is a particular process for initiation of that. I was talking about delaying defaults, default in payments. So this particular notification documents that they categorize defaulters into A, B, C category. So if the delay is more than 3 months, then it's susceptible to inquiry. Again, if I may take you back to this particular slide, this also works to avoid inquiries, because if I pay in the reverse chronology, probably the latest months might appear as paid, and that way the client might escape any PF inquiry. This is a particular judgment from Supreme Court judgment, wherein PF has been levied on all allowance. It's not restricted to basic salary. One more important point, friends, that e-inspection option is available in the EPF login, and employers should track this and ensure if there's any e-inspection notice, it is appropriately responded to avoid any physical inquiry. One more important development, if I may say, friends, is more or less nowadays PF inquiries are online and it happens in a virtual way. Similarly, this notification was issued in 2019 against the Supreme Court judgment, wherein EPFO field offices very, if I may say, rampantly started inquiring various establishment. This is a restrictive order wherein they have been advised to very fairly deal with such cases and not do any roving inquiries. That is the word used in the notification. So I have explained this very critical and important notifications because this might help your client to safeguard themselves from any high-handedness from of the department. One more important point regarding damages is typically on the PF login, damages and interest is displayed under a particular tab. Friends, it is not a concluded liability. It is the department has to go through a quasi-judicial process of issuing a notice under corresponding section, specifically 14B and 7Q for damages and interest. The SSC or establishment gets an opportunity of being heard. When I say opportunity of being heard, I mean you will be asked to present your case why it should not be levied, and then only once the order is passed, then you are liable to pay. So don't let your client panic just because it is appearing on the portal. Unfortunately, there is no escape from penalty, but by not paying that amount immediately appearing on the portal and waiting for this inquiry to happen, you are saving your clients' funds because the amount does not increase. It is frozen. Once you've made the payment, the interest penalty amount is frozen. So let's take advantage of, if I may say, delay on the part of the authorities, wherein I have seen cases where EPFO has issued penalty notice for delays of 2013 in 2020. So let your client utilize those funds for 6-7 years, after which once the notice is issued, if there is no counter, we need to pay that amount. Unfortunately, there's only one way of saving penalty under PF, that is if your client has is a sick unit approved by BIFR, in which a reconstitution plan is approved, under which you need to take a waiver from penalty. We have also used various other legal means where you can apply to CGIT. This is more of a delay tactic wherein you can apply to CGIT against any penalty order. So wherever the amount is large, if you make an application to CGIT meaning Central Government Industrial Tribunal. So it's an appellate authority against any PF orders. And again, you can take a stay order from CGIT, and probably for years, you will save your client from making any penalty payment. I'll just go one by one. So damages, I have already covered some important circulars, CTC concept. One more very typical error, if I may say, which I see is payslip are not very properly presented. Ideally, employee and employer share. Only employee share should reflect in the payslip, because employer share of PF and ESI has to be borne by the company. Even if you are following CTC concept, the wiser presentation would be only to show employee share as deduction, and employer share can work as a hidden adjustment. It should not reflect in payslip, because if it reflects, the authorities might take a view that you are deducting the employer share of PF, ESIC, and then maybe asked to face questions. For non-functional establishments under ESI, you have to file nil returns. In PF, you need to pay 75 rupees challan, which is like a non-functional minimum admin charges challan, which you need to pay. I'm going to come to higher PF contribution towards the end. Very important point regarding provident fund, friends. Specifically establishment search, similar to how you can avail some data is available on public domain on MCA, specifically available for any companies, who are the directors, what are the lien on various assets. Similarly, this information is not very readily available with in the public domain, but in PF you can find out any particular company. So allow me to demonstrate how you can find out the PF contribution history of any company. Okay, so I'll come to this part, but what I meant is that you can find out how much the client has contributed over the last 12 months, and not just that, you can also find out who have been the um, contributors. Of course, the figures are not readily available. So, but you can also find out since when a particular company is registered under PF. So you need not go to the department to find out the code number. Much of the information is available online. Hopefully the site will work. It is. Yeah. So as you can see, friends, this is company's details, wherein you can find out that what is the code number since when the company is registered in PF. And not just that, if you see this particular link, in this link, I can also find out. Now I am demonstrating this because this could be a very good audit tool for you. So like you can see on the screen, friends, very clearly for the last whatever months you want, you can find out what is my PF challan amount, how much I have paid, and TRRN number. So this TRRN number helps me to find out the PF challan as well. Not just that, I can also find out for which employees I have paid PF. So this is a very handy information which can help you in the audit. At the same time, we have been successfully been able to utilize this information for a very different purpose, which, if I may say, is dual employment or moonlighting check, wherein apart from service history overlap, we can also find out if a particular employee has been on the PF record of more than one establishment. So just a short brief as to how we have this has been a very fruitful exercise for many of our clients in IT setup, wherein we have found out amongst whatever employees who are contributing in PF, who have been found to be dually employment. When I say dual employment, what I meant is PF is contributed by two different firms at the same overlapping time, and their service history has also been checked. So and if there's an overlap of PF service history, it can be categorized as a suspect dual employment or a moonlighting case. So it's a very, if I may say, niche, but a very interesting exercise which you can, and which you may have come across in media reports. Also, companies have accessed this information to do dual employment check, but through limited knowledge, what we generally do is we also check on two different fronts. One is service history check, and second is through the establishment history as well. So typically, this is a very good takeaway in terms of also as an audit point that you can find out. You did not ask your client to give you 12 challans and then check their service history. This information is readily available on the PF portal. One very interesting aspect, now this is, I have used the word hacks, it's because this is a very if I may say professional insight which can save lakhs of rupees. Two examples I would like to give, similar to how I explained in Provident Fund under ESIC also. What happens is, you can call it I know, maybe lethargy on the part of department, which you can really benefit. Just allow me to access the paper. Yeah. So this particular, what happens is, if a particular client has not been paying ESIC for a considerable span, say 12, 24 months, what the authorities do is, they, in absence of any information, they tend to issue an ad hoc notice. If you can see here, friends, it is C18 ad hoc. So it is a very big red flag for your clients, because this can be very harmful as well as could be beneficial for you. So what happens is, if say from April 21, my client has not filed ESI returns, then one find up saying May 23, ESI will issue this kind of notice, wherein the ESI authorities will take arrears of contribution, wherein they will contribute arrears, sorry, on ad hoc basis based on a ad hoc employee count. So these are the wages they have taken and the contribution rate. Now, what is the employee count they take to issue ad hoc notice? So they take the last return filed before default. So in the example that I was mentioning, if April 21 is the first month of default, they will find out for how many employees you paid in March 21. And say if you paid for 20 employees, you will be liable to, they will issue ad hoc notice for by assessing dues for 20 employees for the last 24 months. And if you're not able to justify or respond to this, you will be liable to pay. Now, a contrary example is a very typical case. This particular client had paid only for one employee, whereas practically there were many employees on roll. So when this notice was issued, we took it in a positive way, wherein we asked the client to pay because this saved them. Because if any submission of record was done, it would have resulted in an increase in liability. If I'm going through financial distress and probably ESI payment is going to get defaulted, you can just ask your client to, just file ESI for lesser number of individuals and pay ESIC and stop there onwards. So typically department will take last return file and issue an ad hoc notice, which might work in your client's favor. I was talking about how penalty cannot be waived off under PF and ESIC, but again, there's one particular exception only in ESIC. If there is a retrospective coverage as a result of departmental inquiry, say in September 2019, my client was inspected and ESI was implemented from April 14. In this case, I get 21-day window after the inspection to pay backlog dues, and in this case, in the first instance, department had levied damages meaning penalty from April 14 onwards, to which we responded with this notification, and I feel happy to say that we were able to save almost 6 lakh rupees, because as you can see in this scoring item, which is issued by the authorities after issue of order, they have stated that against whatever 10.5 lakh dues has been reduced to almost 4.5 lakh rupees worth of dues. So this is a very important piece of information, although very less, it's the applicability is very particular. But if your client has gone through this retrospective coverage, then you can certainly take benefit of this notification. I already explained how you can do reverse chronology payment and how you can benefit in terms of saving of PF, penalty cost, also some income tax disallowances might be saved, and also inquiry you can escape. I have already talked about maternity benefit. In PF, there is no intra-appellate authority, but in ESIC, you can file an appeal within the department, right? By just paying 25% of dues. So again, this is a very good delay tactic against any order issued for assessment of dues, against which you can file a appeal within 60 days of issue of order, and you just need to pay 25% of dues. Friends, I can say out of whatever experience I have, the appeal are not disposed of very soon, and you get ample time to really, for your client to not pay the dues or which are assessed. So I think this is almost the first part of the presentation is coming to an end. I'll just one word on the apprentices. I come across various books or arrangements where the client says, these are my trainees. Friends, no graduate or degree holder for that matter cannot be treated as trainee unless he is through a government certified scheme. So government has certified schemes under Apprentices Act. One of them is NAPS, or many other schemes were there like NEEM, NATS, and state government schemes are there. Only under these schemes you can enroll degree holders as apprentice. So if you have a trainee who is working for your organization, but he is working with your organization only as a part of his degree course, then he is exempt. And we generally advise our clients to take an NOC from the college or university that he should be working with you as an intern. Apart from this, if once the candidate has achieved his degree or completed his education and is joining your organization as a fresher, either enroll him in all labor laws or enroll him as an apprentice. And one such apprenticeship scheme which is going to be the focus point of the government is NAPS. Under the NAPS scheme, it's a gazetted scheme. You can engage maximum of 25% of workforce, total workforce as apprentice. You get lots of compliance benefits, some of which is you are not liable for any labor laws. You cannot discontinue them at the end of the contract. You also get 25% of stipend, maximum of 1,500 rupees on monthly stipend amount as a refund. So typically, if I engage 20 apprentices in my organization where there are say 80 employees on roll, you can engage a maximum of 20 individuals. Against every individual on a monthly basis, I can make an application for 1,500 per individual. That is 30,000 a month as a subsidy or a benefit under the NAPS scheme. This works very effectively for typically for, if I may say, domestic businesses, family-owned businesses, which are in a growing stage. Major issue is that there is a class of workforce who is unaccounted. If I may use the word, they are paid in cash. So this workforce, the driving factor of not taking them on roll is because you want to save on the labor laws and employees are unwilling. For this, and one of the major losses for your client is they cannot take the deduction in the books. Whereas against this, if you enroll them under the NAPS scheme, you can take them on roll. They are officially, payment is made through a bank channel through the apprenticeship portal. And as a result of this payment, this can be also accounted for in books as an official expense under stipend. So there is a corresponding notification to this. I will not get into that due to time constraint. But I'll take a pause for 2 to 3 minutes. During the course of this pause, I would want to invite to demonstrate a particular video, it's a very, if I may say, touching video on PF benefits. I personally believe it's a fantastic scheme with major rewards, and this particular video will help you understand in what circumstances an individual can withdraw his PF funds. So allow me to share this video.
मेहनत
Ajinkya, are you able to hear the sound? Or anybody? It is audible, right?
थकती नहीं, ख्वाहिशें रुकती नहीं, सपनों की भीड़ में भी आशाएं कभी मरती नहीं। अचानक आंख खुलती है, अपनों की पलकों में भविष्य के सपने दिखते हैं। कोई तो कहता है हो जाएगा, ख्वाहिशें भी हद पार करती है, आसमां को छूने की कोशिश करती है। कोई तो विश्वास दिलाता है हो जाएगा। कभी जिम्मेदारियां अपना हक जताती है, अब भाग नहीं पाओगे ये कहती है। कोई हल्के से कान में कह देता है ये भी हो जाएगा। लगता है कभी कि अब सफर खत्म, बस अब समेटने ही लगते हैं जिंदगी को। कोई तो कंधे पर हाथ रखता है, कहता है हो जाएगा। पतझड़ का मौसम आता है, अपनों का साथ छूटने लगता है, सफर धुंधला सा लगता है। कोई बुढ़ापे की लाठी बनकर कहता है बस हो जाएगा। ईपीएफओ आपके साथ। मेरी पूंजी मेरा भविष्य, बस हो जाएगा।
So I think very interesting video explaining how you can avail advances against your PF contribution. Like I have mentioned at the start of the presentation, I generally advise individuals as well as clients to contribute to PF, and it's comes with lots of benefits to your individuals as well as the company as a whole. So we have discussed majorly PF, ESI, Factories Act and Shop Act provisions. Like I mentioned, I have tried to make justice to whatever time is available and try to specifically touch upon the most important factors which as a professional we should know and which can benefit our clientele. This particular slide very clearly demonstrates which law is applicable after what headcount. I already mentioned that contractual workforce is also applicable. This can be a very helpful slide to understand typically to a HR as to what are the thresholds which he needs to track. I would like to invite your attention to this particular motor transport worker license. So why? Because it could be a very missed this information is not available easily, but if you have a clientele who is into passenger services, right, then he is liable to take a motor transport worker license if he has more than 5 individuals working for him. Apart from this, I have already explained what various laws that are applicable. Above, I'll move to the, if I say second part, wherein I'm going to talk about some other laws and how you can, you need to know this particular slide is helpful for manufacturing and construction sector, where there is contractual workforce through registered contractors. So Contract Labor Act states that in the state of Maharashtra, if any contractor is engaged more than 50 workers at a particular site or a unit, then he needs to take a contract license. Similarly, the principal employer also has to take a license, which is called as RC, if he has engaged at his unit more than 50 workers directly or indirectly through workers through contractors, through one or multiple contractors. One important point, friends, again, this is has a financial implication to this. When a client avails factory contract labor license, a contractor, if he avails a license, applies for 100 labor, he needs to pay a security deposit at the rate of 500 rupees per labor, equivalent to 50,000 rupees. Now, this security deposit which you pay at the time of contract labor license is refundable. So at the end of the contract, you can make an application for refund of this whatever deposit you have paid. This particular license, it's called as BOCW, Building and Other Construction Workers License. applicable to all construction contractors working on a construction site. It need not be just building any infrastructure project like roads, dam, residential or commercial premises. You need to ensure that a contractor avails BOCW license. As a principal employer, it is my responsibility to ensure BOCW compliances, because specifically all my professional friends who have real estate clients, BOCW provision empowers the labor commissioner to issue a stay order if any of the provisions have not been followed. And I have come across cases, of course, extreme cases of violation where there could have been a, say, accident resulting in death or major injury, wherein labor commissioner has issued stay order to which the site was closed for some months, which could have been released only after making application to at the Mumbai office. So it's applicable to more than 10 workers. Under BOCW license, according to me, the builder or real estate developer who is not deputing construction labor is not liable to engage contract, not liable to take BOCW license. In fact, he should push his contractor to take the license. And this I have given officially to CREDA as a definition explaining why contractor is the employer under BOCW Act. So any real estate developer who is taking BOCW license for his under his name is not advised. Similarly, I have also prepared this flow chart again for to CREDA, wherein in a very simple way I have tried to find out which license is applicable to a contractor and of course the principal employer, specifically to the contractor. So these are the applicability provisions under BOCW and labor license contract. One important point is, like I mentioned, is security deposit is refundable. Okay, some important points as charters, we should know this. Payment of bonus act. Again, many clients come and say, Darshan, how much bonus I need to pay? So the first question I ask is, how many years have you been into operation? Because in the first 5 years of operation, when I say operation, I mean starting of manufacturing or commercial activity, the establishment is not liable to pay bonus to its employees unless they have profits in the books of accounts. So typically, many startups have losses in the books, so they're not liable to pay bonus in the first 5 years of operation. Gratuity, very important point, friends, that corresponding provision has to be made in books, and provision for gratuity should be seconded by or supported by funding. So you can have this funded through a LIC group gratuity policy. So LIC has a group gratuity policy, and the benefits of taking this policy I'll explain. Number one, whatever premium you pay to LIC is allowed as expenditure. So you need not wait till actual gratuity payment. You can claim deduction under LIC group gratuity scheme. So say, for example, you have a client who is 10 years into operation and suddenly post COVID in this financial year, it is into majorly into has come into profits. It's showing huge profits. And of course, it has not created any gratuity provision. It's a very apt time to take LIC group gratuity scheme, because they will come up with some premium amount which you're liable to pay to LIC, and that entire amount will be allowed as allowable expenditure in this financial year. Of course, it comes with certain riders that these funds cannot be come back to the company. It has to be utilized only for gratuity payment. One more corresponding and important point is that an employee has to give a nominee to the employer at the time of joining. Under LIC group gratuity scheme, even if employee does not complete 5 years or he completes, and if he expires for whatever reason, there is also a term insurance component involved, which the nominee will be eligible to benefit. There is a law called MLWF Maharashtra Labor Welfare Fund. It has been made completely online. So even employees can make an application for various benefits under MLWF online. I'll give you an example, friends. I have a client wherein a labor was able to finance his child's MPSC tuition fees through MLWF. So MLWF has various, if I may say, lifestyle benefits, meaning some sports facilities are available. and also some scholarships for children. So there are various benefits under MLWF disproportionate to the contribution amount, which is very low. I have already explained the remaining points. Again, under allied laws, one more important point I want to make is under Bonus Act. Okay, you're liable to pay bonus only for employees drawing salary below, or if I may say, pay below 21,000 rupees. So the common accepted norm is pay means basic pay. So if I have an employee with 30,000 salary and his basic is 16,000 rupees, typically I have come across cases where company has paid bonus, to which I have a contrary opinion, which is on wherein according to me, with all possible explanation, all remuneration should be considered, meaning all fixed components of salary. So in the example that I mentioned, if his gross monthly fixed salary is 30,000, he is not eligible for bonus. So you can save your client from this bonus payment or compliance by explaining to him that bonus is payable only where gross salary is below 21,000. One more important point that I come across is many times my clients encounter or face audits wherein auditors ask my client to submit the registered or physical record, to which I have an answer wherein Maharashtra government, even in the Shops Act, it is very categorically stated that you have a notification wherein you can maintain the record in a computerized way. As you can see here, संगणकीय स्वरूपामध्ये संकलन व जतन करण्यास परवानगी देण्यात येत आहे. So this computerized record, of course, if any authorities demand, you are liable to take a printout. I generally advise to take a print every month and keep it on file, but you are allowed to maintain payroll record in an online way. Shop Act, I have already mentioned. Factories Act, under this, I have already mentioned about connected loads, sanction load. I come to almost the end of the session, I think. Yeah, so if I'll take 15 minutes more, then we can open the floor for questions. So labor codes, unfortunately, it has been in the pipeline since 2019. It is an attempt by the government to consolidate 29 different labor laws into 4 different codes, similar to probably what it did in the indirect tax arena. According to me, personally speaking, it is just consolidation of various different laws. They have just consolidated into 4 codes. As verbatim, they have just pasted the laws into different codes with some changes. But irrespective of all the media speculation that has been going around, the question remains when it will get implemented. I'm not too optimistic about it. The reason being, politically, socio-politically, it could not be the best time to implement, if I may say this, controversial codes, because for which there has been major unrest and protest from the unions, and government may not want to take risk in the year when general elections are due. So there are certain ambiguities. It is a very, if I may say, not so carefully drafted code, so it will be premature on my part or anyone's part to give an opinion based on the labor codes which are yet to get implemented. We should continue following whatever laws are in place, because that is how the department and authorities have been operating. What is in store? So what are the major takeaways? So this is very important, because once implemented, you can, if I may say, you can just prepare your client for what is in store. Major takeaways: basic should not be below 50% of gross, because they have come up with a deemed basic concept. They are also going to make it official to have a fixed term employment, much to how it operates in the Western countries. You can have, currently the employment contract is at will, it is indefinite. But you can have a defined end date to a fixed term employment, end date to a fixed term employment contract, and at the end of which the employment is auto terminated. But the only condition is gratuity amongst all other labor laws which have to be paid for this employee. Even gratuity has to be paid. So this is the only exception to gratuity. Apart from this, The gratuity laws continue to be the same in labor code. So there I've seen many queries where people have been saying that gratuity entitlement has been reduced. That is not the case, friends. It's only for fixed term employment. You need to issue appointment letters, offer letters to all class of employees. Group gratuity scheme, wherein as on date, as far as I know, LIC and Bank of Baroda, sorry, Punjab National Bank only have these schemes. So now more players might come in group gratuity and float group gratuity schemes. One important point which I missed is all departmental inquiries, specifically PF, ESIC, there is no time limitation as on date. So I have cases where they have asked for record for last 10 years, 15 years. Unfortunately, there is no limitation period for maintenance of data, unlike GST or income tax law, but they have brought in some kind of, with some riders, limitation period, which is around 5 years for initiation of an inquiry. So which is a welcome change for employers. Also, gig workers, platform or unorganized workers, they will also get social security benefits. So typically, say Zomato delivery boys or Uber drivers, they are also being recognized in the code. So that is a welcome change. They have also tried to standardize and consolidate various returns. Like I mentioned, there are 29 laws. Each of these laws as on date has its own definitions for what is wages, what is employee, and which returns have to be filed. But that is soon going to vanish, and you might end up filing only one return under one code. So apart from, of course, PF, ESR filing. So, and many offenses are being decriminalized and some compounding provisions have been introduced. Now, very important part, friends, on a personal note, I would like to make this advice that do not route employees as consultants. I have already mentioned employer-employee relationship has a very wide coverage. The authorities would want to see a substance over form. I have come across many consultants who have an employee code, who have a leave entitlements, then they cannot be treated as consultants. There is something called as, in PF, there is something called as IW, international worker. So any person holding other than Indian passport, even OCI, that is overseas citizen of India, or PI, person of Indian origin, he might have an Aadhaar, but if he does not hold Indian passport, he is an IW, that is expat in simple language, under PF. And PF laws are much more different for such individuals, and compliances are even more strict in such cases. Do not, this is, if I'm saying, many unexplainable expenses are there, for which probably record is not available, and these are clubbed under labor charges. Please avoid this, because this kind of disclosure in the books you end up facing major dues in PF, ESI inquiries, because we cannot defend such payments because there is no PF, ESI compliance record. The latest, if I may say, media report which I happened to bump into is that a very reputed institute in Pune, I would not want to name that, they have to pay 64 crore dues. If not paid, the trustee or the director will get arrested. So the point I'm trying to make is inquiries are not very, it's not a very, if I'm say, happy experience. If directors are drawing salary, yes, this I'm going to explain with an example. I have also come across cases where individuals are treated under, and deduction under 194C is done, and you might say it's a contract arrangement. Firstly, I don't think it is right as per income tax law. And secondly, I have already mentioned contractual employees are liable. So even if it's a one-person contract, if there is a 194C deduction, department is going to treat him as an employee. So I would advise you all to follow, to avoid these pitfalls. Be careful about how finalization is done from labor law point of view. Pitfalls and check areas. So what you need to check, like I mentioned, consultancy or professional fee should not be disproportionate to salaries. Of course, maybe 5-10% parking of the funds, unless the nature of business is in that way, is fine. But if it's very high, it will be difficult to explain any such inquiry. And as an auditor also, probably you can raise whether these are actually the consultants or employees. I have already explained point number 2. salary statements drawn from various softwares also have consultants record. I advise to maintain that record separately, because then again it's difficult if that record lands up in the authorities' hands. They will it's like you're giving them ammunition to levy these labor laws on the consultants as well. Very important point, friends, which we might miss as auditors also. If employer share is above 7.5 lakh for a particular employee, employer share of PF, NPS and superannuation club together, then amount exceeding 7.5 lakh is taxable. Okay, so this is taxable as perquisite. So as if I may say, as an auditor, if you find an employee with very high contribution of PF, specifically the employer share, say around 80,000 a month, of course he's liable for levy of income tax on the perquisite amount, wherein amount exceeding 7.5 lakh. I think notice period recovery on GST is, to the best of my knowledge, there was a lot of confusion on this topic, but now it is not applicable. Like I mentioned about stipend also. Yes, this is very important point, that you should ideally be disclosing interest and penalty which is accrued as a result of delay in payment. It should be displayed under liabilities, because it is an uncertain liability, or probably a provision should be made in the books of accounts against this. If you want a very ready-made figure, like I mentioned on the PF portal, interest and damages figures are displayed in the employer's login, and you can download and probably use those figures for provisioning. Now this is the last part of the presentation. Very shortly, I'm going to explain what could be the ideal salary structure. So I'm trying to make the most of the available deductions from the income tax point of view. So this is a high salary employee. You might be aware employer share is exempt to the extent of 12% of basic without any upper limit except for that 7.5 lakh. NPS, a maximum of 10% of basic is exempt, even employer share. So what I'm going to do is, I'm going to, as you can see in this presentation or in this slide, the employee is drawing limited his PF to 1800 rupees. He's not contributing to NPS. So if I increase this to actual, so his basic is 2.5 lakh rupees against 5 lakh of gross salary. So I am contributing 30,000 as employee and 30,000 as employer share. And I am also going to opt in for NPS at 10% of basic, which is going to get accommodated in the structure itself. Okay. So indirectly you're recovering from the employee only, even the higher employer PF share, if you're following the CTC concept. So what has happened is, as a result of these two choices on the employee's front, he has saved 2 lakh rupees, friends. He saved 2 lakh rupees towards, of course, I'm considering that he's in the 30% tax slab. So he saved almost 2 lakh rupees towards savings due to increased PF contribution and NPS contribution. So this can be a very helpful tax planning tool for your high salary employees. For that matter, even directors, I generally push my clients or their directors to going for PF contribution. Typically a family managed business or private limited company where, say, husband and wife are managing directors or partners, as explained in this example, if I'll push him to contribute to PF, of course, because he is one of the owners, he won't mind paying additional employer share, for which he will get a deduction in the books of accounts, and at the same time he will be saving PF on a monthly basis, right, on employer share. So annually, wherein he has a basic of 1.25 lakh rupees, he's saving 57,000 rupees of tax. So this is a demonstration of how you can appropriately do the salary structure and extend maximum benefit to your clients, high salaried individuals, or your director employees for that matter. I really thank you all. It has been a wonderful experience to discuss with you, share my learnings with you. I'm really humbled, and I should thank Pune branch of ICI, specifically the committee members, to have given me this opportunity, and I hope I have made justice to whatever platform you have given and allowed me to share whatever my learnings are there to my professional friends. I think we can take some questions and panelists, over to you.
Yeah, hi Darshan.
Yes.
So yeah, we'll go one by one.
Right.
Okay, so first one is ESIC also applicable to company registered
Yes.
as a
Yes.
startup?
Yes. Answer is yes. Irrespective of constitution and what is there, the answer is yes.
Okay. Can you share briefly about annual returns under Shop Act?
Yes, Form R has to be filed with the Labor Commissioner Office. Ideally, it was supposed to be an online process, but that portal is not up and running. So we filed the Form R. Pardon my understanding, but I think the due date is 28th of Feb of the following year. Of course, it follows the calendar year.
Just for everyone who are typing all the questions in the webinar chat, request you to kindly ask under the Q&A tab, so it will be easy. So we'll go next. Now, is consultant included? But I guess this was related to the PF, if I'm not wrong.
Yes, so I have already briefed that. Yeah.
Okay. Does PF need to be
Yes.
deducted on salary of employees on contract basis?
Yes, I would like to explain here. I mean, it's a very funny obsession of the authorities, Ajinkya. When authorities typically say, when we submit, they ask for 26 AS. I don't know what they want to achieve, but 26 AS and 194C details. This is a compulsory record for an inquiry. So when you say 194C, of course, this record is going to go to the department.
Okay, so if any employees are on contract basis, we have to deduct. No, but if he's on the contractor's pay list, we have to ensure that he has done all the deductions, right?
Yes, if employees are engaged to contractor, he should have done all compliances, and you should not stop there. You should take a copy of that and file it as a record for you, because 5 years down the line, when the inspection is going to happen, the contractor is not going to be there, but your record will help you to face the inquiry.
When the labor codes and laws are already cleared by the central government and most of the states already frame rules for these acts, what is stopping the revised laws? So I guess it is about the new labor code. So when it is going to be effective?
Like I mentioned, yes, primarily it was not implemented because states were yet to frame the laws, but rules, but majority of the states have framed the rules, after which it has gone into the back burner, and probably the government is not confident of it, of implementing it from, if I may say, politically, it may not be a very wise choice or timing. But still, 1/4/2023 could well be the date of applicability. Having said that, there was also a word or a speculation that labor codes might get implemented in a phased manner. So I don't have answer exactly when it will get implemented.
Okay. One everyone is asking is that if we can share the presentation along with all the notifications.
Yes.
So if you can
I'll share it to your team and then you can submit. Yes.
Surely. So we will try to make it available on the ICI website.
Okay, great.
One of the educational institute has paid interest and damages. Challan is appearing under miscellaneous challans on PF side, but still delay is appearing under damages and interest. How to adjust his dues against the miscellaneous challans?
If it's appearing under miscellaneous challans, first and foremost, see if it is paid. Mere creation of challan, in PF it operates that first you create a challan and then pay. It does not. So typically, like how you do advance tax, right? You pay them. So first ensure that it is paid, and still interest and damages is appearing on the portal. You like I mentioned in the presentation, you are not anyways liable to pay. It is not a official demand by the authorities. It is merely a feature. So you should wait for any notice to arrive, after which you can respond stating that I have already made this payment against these dues, and then that amount will get reduced.
Okay.
Double payment
there was a double payment for some ECR in April 20. Till date, we have not received the amount back in spite of various follow-up.
So getting the funds back from government, I don't need to tell my professional friends how difficult it is. And PF is all the more difficult because PF has credited the amount in say 20 different employees' accounts. Now imagine if one of those employees has left and withdrawn the fund, how will the PF again reimburse you the duly paid? So my advice would be don't avoid doing that.
Okay.
Yes, yeah.
Leave encashment during FNF is mandatory to be calculated on gross salary or basic salary.
Legally, as per my interpretation, it is on gross salary, but the industry practice is on basic. That is how 90% of the establishments do, pay on basic salary.
Okay, but then is there, suppose during the hearing or during the notices, is there any consequences? So what is?
Fortunately, if I may say, even department is of the view it is of basic, or that is the accepted norm. I'm saying gross salary based on interpretation. If you see the definition of wages in Payment of Wages Act, it is clearly stating all emoluments, inclusive of all allowances. Similar to how I explained about bonus act.
Okay. If salary of employee is 14,000 with basic pay is 7, and then how much PF should be contributed? 12% of 7,000 or of 14,000?
I cannot answer this because I need to see where you have parked the remaining 7,000. If it is say out of 7,000, 2,000 you parked in special allowance, you need to pay PF on that also. So only few allowances are exempt from PF now, unlike how it was previously. So I would advise you to give the exact structure and then I can.
So exemption to take registration under MLWF Act.
No, there is no exemption. Any commercial establishment is liable for MLWF if you have 5 or more employees. Of course, at the employee level, if you have an employee at managerial or supervisory capacity, he is exempt from MLWF contribution.
Can we write off ESI payable dues of previous years reported under Section 43B disallowance booked for the period before obtaining ESI registration never demanded by ESI? Amount involved is 20 lakhs.
I think what you're talking about is a contingent liability because according to you, the law is applicable and the dues are accrued, but it is not, if I say, assessed. So I think you can take a call being probably an audit expert. But yeah, I think writing off in ESIC also at this moment, there is a 5-year limitation period. So if authorities do not issue a notice within 5 years, then probably they will not go back and ask you to pay the dues. But department has powers to make ESI applicable from whatever day it chooses, even say 10 years before. So I would say it can be parked under contingent liability.
Can we write off ESI payable of previous years? Okay, it is the same thing.
No, ESI applicable in so far as Pune district is concerned across the district. This was a very old, probably 2017, before 17, it was applicable only in corporation area, but now it's applicable across Pune district, even many other districts in Maharashtra. Very few districts or areas are not covered under ESI.
Okay. So what are the PF implication in case of dual employment?
Employee might face issue at the time of withdrawal or transfer because the service history might appear overlapped, which might result in withdrawal issues, but it is explainable. So apart from this, pension contribution, if both the employers are contributing maximum pension amount, then one employer's PF contribution might go west because pension eligibility is dependent on not on the amount, but on the periods of service.
Okay.
Who are liable to file annual return under Shop Act. All Shop Act license holders are liable.
Can you briefly touch, if appropriate, the raging judgment on increased pension under EPF?
Unfortunately, it's a very wide topic, difficult to cover, Ajinkya, so I'll skip.
Yeah, surely. Over a period of time, if the monthly salary of employee exceeds, can we exclude him from PF and ESI?
Very good. ESI, yes. From the next April or September, you can exclude if he crosses 21,000. But PF, the law, there's a golden rule called as once a member, always a member. So once he's covered in PF, irrespective of his salary goes beyond 15,000, he's liable to continue to be a PF member.
Yeah. So if he's a new employee, So first time employment and basic is
Above
more than
15,000.
15,000, so it's not applicable.
Yes, and Form 11 has to be availed from.
Yeah. Okay, see then, so the final will, that is okay. Is the SIC applicable to IT sectors? Your employee salary exceed 21,000.
Yeah, no, irrespective of which sector employee works, if it is above 21, it's not applicable. There is a talk which says that probably this limit might increase to 25, but it is a speculation. This has been increased from 15 to 21 in, say, 3-4 years before.
Could you please help us with the procedure for registration of employees? If you
Yeah.
register them late, do we need to submit a documents in hard to officers?
Simran, ESI has a very weird rule of registering members within 10 days of joining, which more or less we default, and against which if you do registration, they issue a show cause notice. I would advise you to ignore that in personal off the record, because it is merely a computer generated notice for which there is no accountability, no trail.
Payment of bonus act. Can the bonus be
No,
out of
yeah.
the salary structure if gross salary is below 21,000, or it should be paid separately over and above salary one time?
Hi Sneha, no, because I don't advise, because it defeats the purpose of the law. Bonus has to be paid by, is corresponding to profitability of an enterprise, which cannot be identified during the course of the year. So it is a reward to the employees. So it should ideally be paid in the form of one-time payment at the end of the year. The law allows you to pay till next October. So the guiding principle is your books will be final till September. You can sorry, till next November you can pay. So for 22-23 you can pay till 30th of November. Although having said that, you can pay bonus in advance or in parts, it is called as intermittent bonus. If you have paid during Diwali, which is a norm, you can call it as a customary bonus. So it's something like a bonus which is paid in advance.
Okay. Interest and damages appearing are they required to be paid?
No, like I mentioned, you can wait through the regular 14B7Q procedure. There is an opportunity of being heard as an establishment. You will get a chance to contest against it. Most probably, it cannot be waived off, but at least you will get a chance, and that way you also get time to pay. The amount is already frozen once you made the payment. So it is not going to increase unless 14B7Q, these are the sections for interest penalty, order is passed. So you have ample time to pay. So it is not mandatory, but if your client wants to pay, you can go ahead and pay, but I do not advise it.
For PF applicability count, is that okay? Basic salary of employee is more than 15,000, so he's not allowed to contribute to ESI as per PF website, and total contribution goes under EPF. What are the consequences of this?
No, I think there's a miss. I think
Yeah,
miss. Yeah, 21,000 is the ESI limit.
21,000 is the.
What is the, so I did not understand this question.
Okay, we'll if whoever has asked if could elaborate more on this, then we can go ahead. I will till the in the meantime I'll go to the next question. Can an organization take Form 11 and not deduct PF from an employee whose PF was getting deducted in previous employment?
I already explained, once a member, always a member. So ideally he should, and if you look from social security point of view, the employee should get covered for his own benefit. So you should push your employee and your client to include such employees. I think it's the same person as an anonymous follow-up questions is being asked. So probably we can skip those questions, and
yeah, it's just okay.
If there's any questions in the chat, we can, but I think those are also asked.
I guess the chat people have already included it over here.
Yes, yes.
In chat mostly it is about the presentation, sharing of the presentation.
One person has asked about Minimum Wages Act. Basically, state government issues minimum wages subject to the sector of establishment, whether it is iron and steel industry or hospital, and also zones are defined, zone 1, 2, 3. So every 6 months DA is announced, and according to the Minimum Wages Act, you need to ensure that your employee who is a full-time employment under employment should be paid according to that.
Whether advance, say function advance given to employees also attract PF deduction. I guess no, it is finally adjusted out through gross, but still you said.
No, only wages or earning through in the form of salary are liable. Any advance is not liable for PF deduction. I think more or less it's about asking to share the PPT.
Yeah, more of it's about sharing only.
Yes.
Then I guess we will conclude over here. All the questions have been answered, and most of the comments that we have received are that it has been an extremely informative session. So I thank today's speaker C.A. Darshan Balai for taking out his time and guiding everyone and sharing his valuable knowledge and giving a informative and practical. I will say it is a practical session from the point of view of an audit. So even hopefully everyone will make use of this information while finalization of the book of accounts for their clients. So and we are surely try to hear more from you, Darshan, on a frequent basis. So we'll conclude over here then. Thank you, everyone.
Thank you, everybody. Thank you, Ajinkya. Thank you, Purina.
Yeah, thank you, Darshan.
It was a pleasure. Yeah.